All right. Hey, Perspectives, part 3 of our 3-video series, in which I answer a couple of other common objections about this knowledge account of legal proof. So you started out by saying, hey, look, actually, this seems like it makes a lot of sense, like to stand up and say, oh, this person might be innocent, but we find him guilty and send him to jail anyway. That sounds really bizarre in the same kind of way that it sounds bizarre to say, yeah, my ticket might have won, but it lost the lottery. And a really natural account of that is, oh yeah, you have to know someone's guilty to convict them. So why have people really shied away from this account? Well, one reason that I want to address now is thinking, oh, well, this knowledge standard is it's really not cool because it's knowledge, it's just so factive. So this is a concern that Georgie Gardner has raised. She said, look, it's a desideratum of an account of legal evidence that if the evidence is compelling but misleading, the burden can be satisfied even if the judgment is false. And Michael Bloom-Tillman has made a similar point. He says, hey, look, there are such things as no-fault wrongful convictions. So what I want to point out here is that when Gardner says, hey, my objection is an innocent defendant can appear guilty beyond reasonable doubt. Well, an innocent defendant can appear guilty beyond reasonable doubt, but I want to say they can be guilty beyond reasonable doubt. So the idea is, look, here's what I totally can get behind. If an innocent defendant is such that everybody's justified in believing they're guilty, and so they're sent to prison, something perfectly fine has happened. Something has worked well. And also something not good has happened. Something has gone wrong because now an innocent person is in jail. And actually the knowledge account can deliver both of those intuitions. It is important that we have an account that can respect both intuitions, and the knowledge account can. So what went wrong? Well, the burden of proof wasn't actually satisfied because they didn't know because the guy didn't do it, so you can't know he did it. But in addition, something did go wrong, and that is, something did go right. And what goes right in a case where, well, we all think we know, and so that's why we sent him to prison, is that the jurors, from their perspective, are doing their very best to satisfy the knowledge norm. And so they are indeed satisfying other higher order norms like, hey, do your best to satisfy all the norms that you're trying to satisfy. And that doesn't mean that, in virtue of doing their very best to satisfy the norm they're supposed to be satisfying, we can say things like, well, those jurors were just blameless. It wasn't their fault that they couldn't satisfy the norm. After all, they did their very best and they thought that they were satisfying it. And that's a very familiar situation to be in, because that's just how life is when you got externalist norms. So suppose I tell you, hey, water my garden if and only if it doesn't rain, because if you water it and it rains, then it's just all the plants are drowning. And so you get up and you look outside and, you see dry ground everywhere and you think, okay, it hasn't rained, you water my garden. Turns out it rained overnight and then the water just sank in ridiculously quickly. So are you actually doing something wrong? Well, yes, you're failing to satisfy the command that I gave you, but are you doing something right? Of course you're doing something right. You're completely blameless for failing to satisfy that norm. So I just want to point out, hey, this is kind of a familiar refrain for fans of knowledge norms, that you can have higher order norms that ride on them. And in fact, it's very useful to have an externalist norm that grounds the different other norms that you might want to apply when judging not only a particular conviction, but maybe in judging jurors and their dispositions to act in certain ways. So that's one thing you can pluck from the literature on knowledge in order to really help out this account of legal proof. And now there's another concern, though, that I think is actually, it's the most fun. And it's actually the one that I care about the most because I think I care about the way in which we answer it. So here's the deal. What we've been talking about so far is, why is statistical evidence insufficient to convict someone of a crime? And here's another thing we do want to explain. Statistical evidence, it's not just insufficient in a criminal case, but it's also not enough to present statistical evidence even when we're in a civil court proceeding, where the relevant standard of proof is not proof beyond a reasonable doubt that someone is guilty of a crime, but rather just proof by a preponderance of the evidence that they're liable for a certain tort. So if I want to, sue you for trespassing on my land, all I got to do is prove by a preponderance of the evidence that you trespassed. And typically, people associate that standard with like the 0.5 threshold. So the idea is, you just go back to Bentham. Bentham says, the practice of wagering affords us some insight into these degrees of belief that we need to have in order to understand these different standards of proof. So even Bentham is basically saying in our current lingo, credences. Like, in order to actually win a lawsuit, you gotta be convincing the judge to have at least 0.5 credence, more than 0.5 credence that you're in the right. So what's that mean? Well, I mean, for one thing, this is an objection that Redmayne spelled out really beautifully in this 2008 article. He says, look, statistical evidence isn't enough to provide even proof by a preponderance of the evidence. If you have 1,000 people who went to a rodeo and 500 of them got there by trespassing, no, let's make it 501. So now a local prosecutor picks somebody at random from the stands and says, okay, well, odds are you trespassed. 0.501 credence that this dude is trespassing. That's what's justified. Is that sufficient to prove by a preponderance of the evidence that he trespassed and thereby allowing me to recover for the damages of him trespassing on my property? I can just, sue him for the cost of the ticket? No. Even in a civil case where the burden of proof is lowered to 0.5 what? It's not sufficient to have merely statistical evidence. That's not sufficient to ground a verdict of liability in a civil case. And we need our account of the insufficiency of statistical evidence to then generalize from the criminal case to civil cases. So if in the criminal case the idea was, well, you have to know someone's guilty in order to convict, Redmayne says, well, it can't be in a civil case. You have to know that they're liable in order to recover, because that is way too harsh of a penalty to impose. And here I'm going to say, I agree. I agree with Redmayne. It is not the case that in order to prove liability, you have to actually prove that this person trespassed on your property. What you have to prove is that it's more likely than not that they trespassed. That's the thing that's required for legal proof sufficient for a verdict of liability. And how can we say that legal proof requires knowledge if what's being proved is this merely probabilistic claim? Well, this is great. I get to have a little trailer for my book. This is how we do it. So we say, what is required is that the judge have at least 0.5 credence that they did it, that he trespassed. And what's required, which is why statistical evidence is insufficient, is really that this belief, this 0.5 credence, is knowledge. Not just, some mere justified 0.501 credence. I mean a 0.501 credence that is not going to be just, they got it right. He was more than 0.501 likely to have trespassed, but that was just kind of luck. I mean, you could have just as easily gotten it wrong when the judge formed that belief, because there was only a tenuous connection to the truth of it. No. It has to be some kind of 0.501 credence that itself constitutes knowledge. What kind of knowledge? Well, probabilistic knowledge. So, here's where, I just got to take, the rest of this, minute to have a little commercial for this idea, because what this book is about, and in fact, let me also just note, I literally am stuck in this house with 9 copies of this book that I just grabbed from my office. So if you're a prospective grad student and you want to find out more about credences and knowledge and how they can, how credences can be knowledge too, send me an email. I will totally mail you a copy of this book, because right now they're just being used to collect dust and as doorstops. But OUP sends the authors all these copies. I'll just mail you one if you're interested. So here's the spiel. If you have this attitude, say 0.501 credence, and it's based in somebody's testimony. It might very well end up being that you know, because someone told you and they knew, that it was actually more likely than not that this person trespassed. But merely statistical evidence in the context of most criminal and most civil proceedings can't by itself ground both justified credence that, high credence that the defendant is liable, but not only that, but also knowledge that it's more likely than not that they trespassed. So probabilistic knowledge allows you to give a kind of unified account of what's missing in cases of statistical evidence, both in the criminal and in the civil context, by saying, in both cases, it's just knowledge that's missing across the board. So if you like, there's a kind of, double axis. So you can have this kind of credence increase, like, 0.96 versus 0.5. That's really talking about the quantity of credence you have in guilt. And that's one way of your epistemic standing with respect to a proposition getting stronger. So if you like a higher bar, quantity-wise for credence is required in a criminal as opposed to civil case. But there's another kind of axis along which you judge your belief, and it's not just, how much credence do you have, but also how good epistemically is that credence. And there's something epistemically crappy about both full beliefs and credences that are based on merely statistical evidence. And you can see that even in just in your ordinary life. Like if you go along and two people are approaching you on the street and you think, well, this person's more likely than this person to assault me. And you're making that judgment based purely on merely statistical evidence about this person's race and that person's race. Something is wrong with that picture, and I don't mean it's just morally wrong to make that judgment, or, maybe there's a dilemma because epistemically you should make it, morally you shouldn't. No, there's something just epistemically really wrong about basing your credences about people. And here I'm not forming a full belief, I'm just saying my credence is greater. No. Even credences get to be judged along this second axis of epistemic quality, and what can be wrong about your credences is simply that they fail to constitute knowledge. So that's legally relevant, but also politically relevant. And so that's the kind of stuff that I'm super interested in, and and I think it's just super fertile as a potential ground of engagement of formal philosophy with, the real world. So go blue. I'm at 12 minutes, 30 seconds. And get in touch, please. Email if you have any other questions about statistical evidence, about the interface of epistemology and law, about Michigan, or just about life in general. So again, sloths, fun animal facts, send me an email, and I look forward to hopefully meeting at least a good many of you in person when all this is over, and soon. Bye.